Chicago's Morning Answer continues next on AM 560. The Answer.
Now, from the Signature Bank Studios.
Only the biggest stories, only the biggest guests, and only the biggest opinions. This is AM 560, The Answer.
Top of the morning, Dan and Amy. So the prosecution has rested. The defense has rested. Closing arguments Tuesday in the Trump business records trial.
Which means they get a 4-day weekend and they could jump on social media, the jurors. They can talk to their family members. They can read the headlines as they freely walk around New York City.
That star witness was something. I thought that Michael Cohen was going to have some credibility issues, coming in as a convicted perjurer and a disbarred attorney. And then you threw admitted embezzler onto the pile, too. I thought that was... does your star witness have any credibility problems? No, not at all. Should we believe him? No, of course. I mean, and there's one other thing, too, that we have on tape, which is he admitted that he's got a vendetta against Trump.
Right.
So
I truly hope that this man ends up in prison. It won't bring back the year that I lost or the damage done to my family, but revenge is a dish best served cold. And you better believe I want this.
Yeah,
he's made millions on books about Trump. What's he biatching about? But here's Trump as he left court yesterday. The defense rested and he didn't testify.
The White House is the person or the group, whatever. They're the one trying this case. You heard who was doing all the talking. Representative from the White House. Just recently. This is all about Biden. Can't campaign, so he's trying to injure his opponent. They're trying to hurt the opponent because they can't win it fair and square. It's lawfare. There are a lot of terms for it. It's a third world country way of campaigning. Such a disgrace. So sad to see what's happened to our country. Our country's going to hell under Biden.
Yeah, it's sort of the staying on message. I get it. George Washington law professor Jonathan Turley, who has been covering the trial for Fox, has been in the courtroom. We've talked about some of his comments before. He offered this commentary with respect to Judge Merchan, who is central in this case for a lot of reasons, including the likelihood that he has a big decision before him in the offing, which is whether or not to issue a directed verdict that dismisses the charges against Trump. Take a listen to Turley.
I believe that there are layers of reversible error in this case. And what is often the case is you see judges committing errors like this, and then they try to sort of do a Charlie Brown with the football motion, and at the last minute put in an instruction to clean it up. I don't think they can clean it up here. So what Merchan is suggesting is I'll instruct the jury on all of the references to campaign violations. I think that's coming really too late. This jury has been told over and over again, from opening argument to Pecker to Michael Cohen to the prosecutors, the judge has allowed them to say there were election violations. I'm quite convinced that jury believes that there were election violations, even though none have occurred in this case with regard to Trump.
Wow. Just to quote you, the trial is riddled reversible error. The judge has shown serious bias in his rulings. His rulings are often difficult to square with the rules of evidence. Costello is losing patience with the judge, as many of us were. That's not a glowing review from Turley, is it, Dana?
It was Hemmer and Dana Perino, of course, commenting on Turley's observations. A rather comprehensive indictment. Merchan's performance almost mirrors Cohen in a certain respect. For more on this trial and the pending outcome and other presidential legal matters, please be joined by James Burnham, former senior associate counsel to the president, deputy assistant attorney general at DOJ, and counselor to the attorney general. He is now the principal at King Street Legal. James Burnham, thanks for joining us. Appreciate it.
Yeah, thanks, Dan. Thanks for having me.
So what did you think of Turley's summation, and do you have any intuition on the outcome in this case?
So look, I have not followed it as closely as Jonathan has, but my sense is that, Justice Merchan, they call the judge's justice in New York at the trial court level, is obviously not on the president's side, and I don't see him doing any favors. And I would like to see a hung jury or an acquittal, because I think this case is ridiculous, but it is very difficult to get that when the judge is openly hostile to you, and that's before you get to the sort of difficult jury pool you have in New York City. So it's just hard to say. But the president has an uphill battle, of course.
One decision that was interesting. I mean, the decision for him not to testify was pretty obvious, but the decision to not call Bradley Smith, former FEC commissioner, to Turley's point about the repeated references to campaign finance violations, that Trump has not been found guilty of any campaign finance violation, but Bradley Smith was on their witness list, but the judge put some constraints on as to what he could testify to, and the defense chose not to call him. How did you interpret that?
Yeah, I mean, I think that they concluded quite reasonably that if Justice Merchan was not going to let him talk about anything relevant to the guilt or innocence of the president, that it wasn't really worth calling him, to have him just sort of, read the federal campaign law out loud or whatever it was that the justice was going to let him do. I mean, it is by far, there's many things about this case that are bizarre and unprecedented, but the attempt to convict the president indirectly of a very theory of federal campaign finance law is perhaps the strangest part. And so I have no idea what the New York appellate courts are going to think of that if the president is convicted, but it's deeply, deeply troubling. I mean, it's very hard to imagine the Justice Department filing charges against somebody on that same theory under federal campaign finance law. Indeed, they haven't. Indeed, they did not. And yet now you've got Alvin Bragg trying to backdoor it in through a records case. I mean, it's just a completely bizarre maneuver. And that's before you get to the fact that it's the first ever prosecution of a former president. Itself a terrible thing to do. Go ahead, please.
Yeah, no, I think it's hard for the average news consumer to wrap their heads around this case, because I think that some think that this is about a sex case that happened 20 years ago when there was not a Me Too moment. But what is the charge? What is the crime?
Yeah, that's a very good question. So as I understand it, the allegation is that in internal books and records at the Trump Organization, books that nobody else was ever going to see, they booked money that was intended to compensate Stormy Daniels for the NDA as legal fees to Michael Cohen. Okay, so that's the false entry, supposedly, and that it's a felony because it was in furtherance of a campaign violation, which was using personal funds or corporate funds or Michael Cohen's funds to do a campaign expense, when the federal campaign laws say you can only contribute whatever it is, $2,600 or whatever it is per person. Among the many insane implications of this theory are that the president would have had to use campaign donations to pay Stormy Daniels the money for the NDA because it was a campaign expense. Now, imagine the outcry if it had turned out that the president was using small dollar donors to pay Stormy Daniels for an NDA. I mean, he would get indicted that way too. So the whole thing is just a, darned if you do, darned if you don't trap, in my opinion.
I wanted to get your reaction to the news out yesterday with respect to court filings in the classified doc case, and the filings including the FBI documents related to authorizing the raid and all the logistics and contingencies associated with that, and of course the headline being that federal law enforcement officials had the right to use deadly force as necessary, and then there's this limiting. All these limiting language in terms of the use of force, and this is being received by some as, oh my gosh, they were willing to use deadly force against the president of the United States and his family, and so on and so forth. And I had a different read on it. I know the FBI said basically this was standard operating procedure, but some people are suggesting it could have been a blue-on-blue conflict because FBI and Secret Service and who has jurisdiction and so forth. But, I mean, did you see anything that, with respect to this specifically, that would not be consistent with DOJ and FBI protocols in such an instance as a raid?
No, Dan, I think I have the same reaction you do. I mean, there's some, there's some mid-level administrator at the FBI probably who puts these papers together for every raid, and I would be very surprised that that is not a standard, part of every warrant or every, SOP for the raid, because of course, right, if they're going to send people in, they have to have protocols in place in case there's a confrontation. I suspect nobody thought about this at all, and everyone is scrambling now to try to reassure the public that this was not some extraordinary step they took in this case, but sort of a standard thing, which is not to say the raid was appropriate.
No, right, different, right.
But I don't think, I think this does not strike me as a real issue, the deadly force thing.
Mm-hmm. Okay. All right. I just want to make sure I was on the right page there, because people that other conservatives are out there trying to whip up frenzy, and it didn't seem to me that it's probably warranted in this case. I wanted to get also to your views as expressed in an op-ed you did on the Wall Street Journal about Biden's claim to executive privilege over an audio recording of the interview he did with special counsel Robert Hur, and which Merrick Garland is facing censure over for not releasing.
Mm-hmm. Yeah, I mean, it's an interesting issue. So many people think, to the extent that people have the mental energy to even track this with all the other things going on, that the president asserted privilege over the tapes because the interview was with him. But that's not actually what he's saying. What he's saying is, so first of all, he asserted privilege over the tape of his interview and also his ghostwriter's interview, so a private citizen. And the argument they're making is that the Justice Department is part of the executive branch, and so he can assert executive privilege over at the Justice Department over everything it did in the Hur investigation. That is a pretty broad claim to begin with. It's especially bizarre when you've released the tapes. And it's really bizarre when you've released the transcripts. And it's especially bizarre when you've accused special counsel Hur of distorting the interview. I don't think you can go out and say, well, here's a transcript, Hur's a liar, this is all nonsense, but by the way, you can't have the tapes. I think that's very difficult to defend legally or politically.
Well, also, too, I mean, don't you waive executive privilege if you agree to the interview in the first place?
So that's unclear. We could have taken the position in the last administration when I was there that the entire Mueller report, all the materials, all of that was privileged because Robert Mueller was within the executive branch. And so there's an argument you could make that an internal interview doesn't waive privilege. But whatever we think about that, once you've released the report, once you've released the transcript to the public, to Congress, then I think there's no argument or no good argument that you haven't waived privilege over the tapes.
Well, the other issue, it seemed to me, when this came out, is that then he made this assertion, is that you're asserting executive privilege over things you did that are being investigated when you were vice president and senator. So how would executive privilege cover that?
Yeah, no, exactly. So that's why it's sort of almost impossible to explain in under 5 minutes. But basically, so the Department of Justice is part of the executive branch. Their argument is DOJ conducted this investigation. I can assert privilege as the president who supervises DOJ over DOJ investigations. Therefore, I'm asserting privilege over this part of Hur's investigation. So to put it another way, the privilege is actually coming from the DOJ side, not from the White House side. And that's how he can justify suppressing the tape, is that it's DOJ's property. It has nothing to do with the fact that he is also the subject of the interview. He could have made the same argument to suppress tapes of the ghostwriter, of you, of me, of anybody else.
So that would be a wild expansion of executive privilege, wouldn't it?
It has been asserted before that the president can do privilege over DOJ investigations. That is not unprecedented. The courts have never blessed it that I'm aware of. And so all of this is pretty frontier territory. What makes this even more absurd, though, than any of that is that he already released the transcripts.
Right.
So what are we talking about? So the public doesn't get to know whether the transcript's accurate. Nixon tried that too. If you remember the history, Nixon released transcripts of the Watergate tapes and said, let's all, isn't that good enough? And, we all know how that ended.
Yeah, where are all our Woodwards and Bernsteins today? Yeah,
exactly.
James Burnham, former senior associate counsel to the president, deputy assistant attorney general at DOJ, and counselor to the attorney general. He is now the principal at King Street Legal. James Burnham, thanks again for joining us. Appreciate it.
Thanks, Dan. Thanks, Amy.
Thank you. And he joined us on our turnkey.pro answer line.
You're listening to Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
Parents, grandparents, you might want to be sitting down because this is amazing news. Imagine the student in your family not asking you for money to pay for college, or better yet, not getting into years and years of debt.